Good morning, this is Earl White, real estate attorney. This week's video is about dealing with a specific type of inspection waiver that's often called, waiving everything except structural, environmental, and mechanical defects. This has been very common since COVID in the real estate market the last couple of years with buyers waiving everything except structural, environmental, and mechanical. So we're going to talk about what does it mean to waive something for purposes of an inspection contingency. What does structural, environmental, mechanical mean? And what are some strategies for mitigating risks associated with this waiver? So first, what is a waiver? A waiver means that the buyer, for purposes of their inspection contingency, they are agreeing they are not legally allowed to raise defects other than structural, environmental, and mechanical. So anything that doesn't fit those buckets, you can't raise. So if you discover a problem at the property, regardless of price, regardless of the amount or the cost, it can be a huge problem of a large magnitude, but if it doesn't fit the structural, environmental, or mechanical bucket, then the buyer can't raise it and the buyer can't cancel the deal. And so if they fail to fulfill the deal because of that problem, they could lose their deposit or end up in a lawsuit, in a losing side of a lawsuit, if they don't have other coverage or other ways out of the deal. So that's what a waiver is. You lose your right to cancel a deal if the seller does not correct that specific item that you had waived. So next, what does structural, environmental, mechanical mean? Because the language for the waiver usually is the buyer waives all inspections with the exception of structural, environmental, and mechanical. So then, well, what is structural, environmental, mechanical? The things you can raise if you're using this specific type of waiver. Structural, foundation, anything that supports the integrity of the building. So beams, foundation, anything else, like if a chimney is built into the foundation, something like that, where if you would remove it or it would be damaged, it would impact the structural integrity of the building. Mechanical, anything of a machine, most people would interpret mechanical to also include plumbing, all the HVAC systems, so heating, cooling systems. And then for environmental, you have radon, asbestos, mold, pests, things of that nature would also fall under the environmental. So those items you get coverage for, which is pretty broad. So if you have a full coverage for environmental, mechanical, and structural, you do have a decent amount of coverage. So you're not waiving everything. Now, again, there's still a risk. You're still waiving everything that doesn't fit into those buckets, which could be a significant risk. The other risk here is that the parties could dispute what is structural, environmental, and mechanical. There's no case, there's no statute, there's no specific law that defines what any of those words mean. So it's basically they're a reasonable interpreter of what those words mean. So how can you mitigate the risk? The risks with making this type of waiver? First is you can define those terms in an attorney review rider, in a contract, define them somewhere. And this way there is a set definition that we can point to. So for example, if we're dealing with mechanical, most people would say it includes plumbing and electric and HVAC systems, right? But you could specifically put in the attorney review rider, mechanical, including but not limited to HVAC systems, electrical defects, and plumbing. This way there's no disputes or gray areas and no one is going to, the seller side will at least have less arguments to say something doesn't fit that category. And then say for structural, a lot of times you can see disputes, is a roof structural, is a chimney structural? So you could say structural including roof, including but not limited to roof and chimney. For environmental, most people would, obviously chemicals are environmental, but you could also do the same thing, including but not limited to mold, asbestos, oil tanks. So you can define it. So by defining it, and if you actually get detailed with your definitions of structural, environmental, mechanical, there's not that much you're not covered for, right? So as long as you can plug the gray areas, you can get coverage for most things, and also remove the ambiguity that might happen if a seller takes a position that that's not structural or that's not environmental. In which case, if you didn't define it, then it is a little gray, and reasonable people could differ. In which case, we'll go to a judge if the parties couldn't settle it amicably. So that's one way to mitigate the risk, is to define those terms, make them a little broader so it's clear you have more coverage than less. Another thing you can do to limit the risk is do like a catch-all. So for example, you have coverage for electrical, mechanical, and structural, and then add this in. And anything else, any other defects at the property that cost greater than $5,000 to repair or $2,500 to repair, whatever number the parties can agree to. But basically the idea here is that you're only going to raise those three buckets of issues: the environmental, mechanical, and structural, and then you can raise anything else if it costs greater than X amount. And this way the buyer is protected in the sense that if there is something, if there is a dispute, if there's a dispute about whether something's structural, environmental, mechanical on a major issue, you don't have to worry because you're covered, because you have every other defect that costs greater than X amount of money, and then the buyer has coverage there. That's another way you can mitigate the risk. Now, you might not. Now, this is a client's choice. You may not want to engage in building out the definitions. Like, so if the contract comes to the attorney, and attorney review saying, buyer waives all defects except structural, environmental, mechanical, the buyer, as buyer's choice, you may not want to expand the definitions, or you may not want to add a catch-all because you don't want to be looked at as renegotiating the deal, or you may not want to be looked at as going back on what you had indicated to the seller. So there's choice there, but a lot of times the clients will come to me and they'll say something like, "Oh, I'm just waiving major items." Like that. That's was their understanding upon signing something that says electrical, structural, environmental. But it's not really major or minor, right? Structural, environmental are buckets, are categories, are types of things. It has nothing to do with something being large. It has nothing to do with something being small. It has to do with the category of an item. So if you want to get coverage for major things, then you could use something like the price limitation. I said, well, all other items that cost greater than $2,500 to repair. And if you're on the seller side of that and they're bringing these requests and the buyer wants to expand in certain categories, you could either push back on the definitions to kind of limit how they're trying to expand it. And if they want to put it like towards a major item, like something like the buyer wants to add in all other items that cost greater than $2,500, you could say, okay, fine. But what I'm going to insist on is a written quote from a licensed contractor, licensed and qualified contractor, demonstrating the cost of that repair is that number. And then it's going to kind of hold the buyers honest, because nobody wants to waste a bunch of time. So if they know they can't get that quote, they're not going to want to spend 4 or 5 hours of their life trying to get a fabricated quote. I mean, I guess they could, but most of my clients, at least, that are proceeding in good faith, are not going to go get a quote just to play a game. If they know they can't get a quote for $2,500, they're just going to move forward with the deal rather than trying to put something together to do that. So yeah, one way to kind of mitigate your risk as the seller, if the buyer is trying to introduce some of these concepts, is to make them get a written quote. The written quote to support whatever amount they're claiming it is. And so that's another strategy there. So guys, hope this was helpful in understanding structural, environmental, mechanical, how it impacts the deal in some ways that buyers can mitigate their risks with this type of inspection waiver. Thank you.